Namaskar and welcome back to my channel. Today we are going to cover an important topic, that is Employee Pension Scheme 95 and the latest Supreme Court judgment released last year in November 22. Since the time this Supreme Court judgment has come into force, we are seeing a lot of people, especially the employees, the retired employees, the ex-employees who have spent their lot of money in their pension are raising a lot of queries as to what is this Supreme Court judgment all about. Should we put money into the new pension scheme or not? So help out the ex-employees and the employees. This is a small video giving a brief about the pension scheme and the Supreme Court judgment. So let's get started. First of all, let us see what are we going to cover in this particular video. We are going to see what is the pension scheme all about, what are the various kind of contributions in the pension scheme, what is this EPS 95 scheme which came into force in 1995, what are the various legal cases on the scheme which came after the scheme was launched in 95, and the latest judgment, important highlights of the latest judgment of Supreme Court of 4th November 22. So we'll start with what is employee pension scheme. See, this is a pension scheme. It is a kind of social security which is provided by the Government of India, by the organization that is Employee Provident Fund Organization, EPFO, authorized by Government of India. So in this scheme, employees are given the provisions of who are working in the organized sector. They can contribute a small amount to their pension for their retirement at the age of 58 years. However, the benefits of this scheme can only be availed if the employee has provided a service of at least 10 years, and this need not be a continuous service. This scheme has been launched, and we'll talk about the 95 scheme which was introduced in 1995 under the EPF and MP Act 1952. We'll talk about this a little later. So basically the pension scheme talks about the contribution which employee makes for a small amount of social security which the employee will be getting after the retirement. What is the eligibility criteria to be a part of this pension scheme? As I have already shared, that this is a pension scheme which is governed by EPFO, that is Employee Provident Fund Organization. So first of all, the employee must be a member of this EPFO. And how does an employee become a member? By contributing the share of salary, that is basic plus DA, towards the pension. We'll see later on what are the percentage which the employee and the employer has to give into it. Then employee should have completed at least 10 years of service. Employee should have reached the age of 58. But this can be, EPS can start at the age of 50 also, at a reduced rate, that is 4% reduced rate every year. And also this pension can be deferred by the employee for 2 years, from 59 years, that is up to the age of 60. But the employee will get a higher additional rate of 4% each year. So there are 5 important criteria for this an employee to be eligible for EPS scheme. Next, we see what are the contributions of the pension scheme. If we talk about our salary structure, we always see that there is some percentage which is contributed by the employee, and there are some percentage which is contributed by the employer towards this pension scheme. So let us see this. Overall, the pension fund or the EPFO scheme has basically 3 components. One is the EPF, that is Employee Provident Fund. The second is Employee Pension Scheme, that is EPS, and the third is EDLI, that is Employee Deposit Linked Scheme, that is an insurance scheme which is being running by the EPFO organization and is being useful in case of the unforeseen death of the employee during the service period. So let us see the contributions of employee as well as the employer in all these 3 parts, I will say subsets of the pension fund. If we talk about the employee contribution, we can see that the employee contributes 12% of basic pay plus DA on the pension fund, and the employer contributes 3.67% of basic pay and DA on the pension fund. Whereas there is no contribution from the employee side to the pension scheme, and there is 8.33% of basic pay plus DA which is given to the employer's contribution towards the pension scheme. In EDLI, again, there is no contribution from the employee, but 0.5% percentage subject to a maximum of rupees 75 is given by the employer towards the EDLI. This EDLI, I repeat, it is employee deposit linked insurance scheme, and it is applicable only in the case of if the employee dies during the service period. So the main important component is this 3.67 percentage of basic pay, which is given by the employer on pension fund, and 8.33% of basic pay plus DA, which is given in the pension fund. 3.67 in the provident fund, 8.33 in the pension fund. If we total this 3.67 plus 8.33, we get a figure of 12%. So equal amount from the employee, that is 12%, and the employer, that is 12%, is given towards this EPFO scheme, that is the pension corpus or the pension fund, right? So if we take an example, small example, if we see that if there is an employee with basic pay of 10,000 rupees and a DA of 3,000, total basic pay plus DA becomes 13,000. The employee contribution will be 12% of 13,000, that is 1560 rupees in the provident fund. The employer contribution will be 3.67 of this 13,000, that is 4770. And in EPS, employee need not contribute anything. Employer contribution will be 8.33% of 13,000, that is 1083. If we total this 1083 and 477, we get a 12%, that is 1560 amount, which is equal to the employee and the employer contribution. EDLI remains the same, 0.05, right? So this is a small explanation. Now, from where does the question arise or the problem arise? Now, the problem arises in case of employee, this EPS scheme, the employee can maximum contribute to rupees 15,000 only in the pension scheme. That is 8.33% of 15,000 becomes 1250. Maximum of contribution of rupees 1250, 1250 rupees can only be given by the employee even if the salary is more than 15,000 rupees. So this is the maximum contribution as of now which can be given before the Supreme Court judgment which came last year. Okay, so from there the problem actually arises because the basic pay plus DA exceeds even more than 15,000 for many employees. So what about those employees? What about the pension scheme for those particular employees? So we'll see all these later on. So if we talk about how much pension I will get at the end of my retirement. So pension calculation formula is that EPS, that is employee pension scheme, or the amount is equal to pensionable salary multiplied by the pensionable service divided by 70. This is the figure, the formula for calculating. Now what is pensionable salary? According to the latest judgment, the pensionable salary is the average of the last 5 years basic pay plus DA at the time of retirement. So this employee becomes eligible for EPS at the age of 58. So last 5 years of 58, the basic pay of plus DA of last 60 months before the retirement, the average of that becomes the pensionable salary. Now, what about the pensionable service? Pensionable service is number of year of service, and a plus which is rounded off for 6 months. Say for example, if your service is 11 years, 7 months, it will be rounded off to 12 years. And for every 20 years of service employee, if an employee has rendered 20 years of service, so plus 2 years of service added benefit is given is added in the pensionable service. So pension amount is very simple. The pensionable salary at the time of retirement into the pensionable service, number of years of service which you have rendered, divided by 70. That will give the EPS amount, right? So next question is, what is this EPS 95 scheme? This was a brief of the overall EPS scheme and the contributions. Now if we talk about EPS 95 scheme, this scheme was running even before 95 according to the Employees Provident Fund and Miscellaneous Provisions Act 1952. But this scheme 95 came into force on 16th November 1995 by Government of India. Number 2, this scheme is managed by EPFO, Employee Provident Fund Organization, and the amount of pension This is made by the EPFO only. Now, as I have already told, the contribution from the employee side and the employer side together goes to this EPFO, and EPFO manages the fund and releases the pension of the employees. So there is no contribution. So we can say that the employer does not have much say into it. The employer has to only contribute his or her share, the employer share, into the EPFO, the pension corpus of the employee. Then the pensionable salary, according to this scheme, the pensionable salary is considered maximum rupees 15,000 only. So even if an employee has salary more than 15,000, for the EPS, for the pension scheme, this salary will be considered only rupees 15,000 or even lesser than that. And this scheme of 1995 also says that those employees who have joined the service after 1st September 2014 and who are drawing a monthly salary more than 15,000 are not eligible to become an EPS member. So this was the scheme which came into force, the highlighting points of the scheme. Then there were several amendments which were made in the scheme. For example, in 96 there was an amendment of addition of clause 11.3. This is a very important clause. I request everyone to have attention to this particular amendment which was done in 96, which says that this clause 11.3, it permitted an employee to opt jointly by the employer and the employee to contribute on the actual salary in place of the wage ceiling which was fixed. That time the wage ceiling was fixed to 6,500, which later on revised to 15,000 in 2014 amendment. So there was an option in 1996 which was there for an employee to opt whether he wants to contribute more in the pension on the actual salary drawn rather than the ceiling, wage ceiling which was defined in the act. So on 2001, this wage ceiling again increased to 6,500. It was even lesser than 6,500 before 2001. And the important amendment which came on 1st September 2014. The first point was that change in the method of calculation of pensionable salary. Before 1st September 2014, the pensionable salary was only for 1 year, for last 1 year. But after 2014, 1st September 2014 amendment, this pensionable salary became average of last 60 months salary, as I have told in the last slides, in place of average of 12 months. Second, this 2014 amendment also said that pensionable salary to be computed in two parts, separately for service up to 31st August 2015 on the wage ceiling of 6,500, and after from 1st September 2014 the wage ceiling will be 15,000. So there were two components. Till 2014, August 2014, the ceiling will be 6,500. After 1st September the ceiling will be 15,000. Then third point is deletion of the para 11.3 to submit option. So in this 2014 judgment, this para of option given to the employee was totally removed and deleted. From here the controversy actually started. Point number D is requirement to submit fresh option as per 11.4 within 6 months to contribute on actual salary. But there was also given an option that employee can contribute on the actual salary who were contributing to higher salary who had opted. And this option was given only for 6 months from 1st September 2014. And the beauty is that this 6 month was not known to many of the employees and this option was left out. And this 2014 amendment also placed an extra burden on the employee, that additional contribution of 1.16% employee members have to give if they opt that they are going on the higher salary for in place of the wage ceiling of 15,000. So if I, for example, in 2014 I decide that I need not limit my salary to 15,000 and I did not limit my pension contribution to 8.33% of 15,000. I rather go for 8.33% of my actual salary. So this 2014 amendment said that I need to contribute extra 1.16% of my actual salary towards the EPFO for getting this increased contribution made to my pension corpus. So this was not correct, and this is the stage from where the dispute started. So now, what are the various legal cases which came up in on the scheme? So if we talk about the court cases and decisions, the major case in this particular EPS judgment is RC Gupta and others versus RPFC, EPFO and others in 2016. What was the matter of dispute? The dispute was regarding the cutoff date for submission of option or joint declaration by the employee and an employer to opt for pension on higher wages under 11.3 of the EPS scheme. So EPS scheme said that the employee can opt have a joint declaration from the employer and the employee. So the problem was, what is the cutoff date? When can the employee actually opt for? When he becomes eligible for the EPS scheme, when he becomes eligible for retirement, or when the scheme was launched in 95, or the amendment in 2014. I mean, this was the matter of dispute. As per EPFO, this option was to be exercised immediately when salary exceeded the wage ceiling or from the date of commencement of the scheme and not a later date. So EPFO was very clear on this point, and they said that this option has to be exercised immediately when the salary of the wage ceiling exceeds. The moment the salary exceeds 15,000, the person has to opt for going for joint declaration by the employee and the employer for a higher wages, right, and not a later stage. So EPFO didn't wanted to go ahead with this particular scheme of joint option on a higher, because they have to give an increased pension if the employee opts for higher ceiling amount, higher salary on 8.33% on the higher basic pay plus DA. So they had this point. Now, Shri RC Gupta and few other employees who were contributing to PF on actual salary and on EPF on wage ceilings as applicable to 5,600, 500, or at the time of retirement, they had opted to contribute to on the actual salary. They wanted to do it on the actual salary rather than the ceiling amount, with a plea that this provision was not within their knowledge. It was a case of unexempted establishment where both PF and EPS are deposited with RPO. So exempted establishment are those establishments which are exempted from EPFO, means they have their own PF trust, whereas unexempted establishments are those which have their pension which are connected to EPFO for their pension corpus. So RC Gupta and few employees said that they wanted to have a joint, option to contribute at the higher actual salary rather than the ceiling limit. But the option was rejected by the concerned EPFO, saying that it cannot be accepted at the time of their retirement. So, whereas writ petitions were filed by agreed employees, and those were decided by the High Court single judge in favor of the employees. But EPFO went for the appeal, and the decision was reversed by divisional bench, and it was passed in favor of EPFO. Then matter went to Supreme Court as a special leave petition, and finally which was decided on 4th of October 2016 in favor of applicants. And what is that decision of Supreme Court? Let us see, which was given in 2016. Now, in 2016, the decision of Supreme Court came that once the employee is contributing to PF on actual salary and not on maximum salary ceiling by exercising the option joint para option under 26x6 of EPS, then such employee are entitled to exercising option of 11.3 of the EPS scheme at any time. I mean, it means there is no time limit or cut-off time. The employee can any time go for the joint option on the higher salary. Supreme Court observed that beneficial schemes like EPS 95 ought not to be allowed to be defeated by the reference of a cutoff date. So this cannot be, these kind of beneficial schemes cannot be, deleted. So Supreme Court further directed that if the employee has withdrawn his PF, all the amount the employee has taken out from the PF, and he wants to go for extra pension on the increased salary, then he or she has to should be asked to return such amount with interest, and then he will be eligible for pension on actual salary by exercising the option of 11.3 of the scheme. So that's very obvious, because pension will be made from the pension corpus which is available with EPFO, and that pension corpus is your provident fund corpus. Now from the provident fund corpus you have to take out, which you have already taken, you have to give it back. The money has to be given to back to pension corpus, and from that pension corpus, the actual provident fund corpus, the pension amount will be calculated. on the increased salary, on actual salary. So, as per the Supreme Court judgment in R.C. Gupta case, even retired employees who retired prior to 1st September 2014 were eligible to exercise this option to contribute on actual salary for higher pension. So, this was the major decision of 2016. But now that decision was not favoring EPFO, it was not favoring Government of India. So, there were subsequent court cases in high courts and Supreme Courts regarding the change in definition of pensionable salary. EPFO was not very satisfied. The employees were not very satisfied because if we calculate pensionable salary of last 5 years, the amount will the amount will be lesser. If we calculate on only for 1 year, last 1 year, the basic pay and DA would be much higher. So this was not acceptable to employees. They were filing subsequent cases and writ petitions. Then regarding 1.16 additional contribution by the employees were not very happy with this decision. Then time limits of 6 months for submission of joint as per the EPF scheme, this was also not acceptable. Then EPF contempt of court was filed by many employees for EPFO by not paying higher pension. Even if the RC Gupta case was to all members of EPS 95, still they were not paying the higher pension even after Supreme Court judgment. So what were the orders of High Court in that case? The High Court of Kerala, the divisional bench in 2018, passed the order in favor of the members and set aside the amendments of the EPS scheme of 1st September 2014. In line with decision of Kerala High Court, similar judgment was passed by High Courts of Delhi and High Court of Rajasthan. All the above High Courts ordered the EPFO members, the employees, and they are entitled to exercise the options under 11.3, and there were no cut-off date to exercise options, as which is already decided in the Supreme Court RC Gupta case. But the employees were feeling, the EPFO was feeling aggrieved, so they filed SLP against the High Court orders. Union of India also filed appeal in the Supreme Court against the orders of High Court. Apart from SLPs by EPF and Union of India, there were writ petitions which are also filed by the employees themselves on behalf of Article 32 of the Constitution regarding this particular case. So let's see the landmark judgment which came after all these controversies happened in November 2022, the Supreme Court judgment. So Supreme Court on 4th November 22 gave a decision in favor of the employees as like this. If we talk about how it favored the EPFO or Government of India, they said that whatever amendments were made on 1st September 2014 are valid and legal. They said that there shall be no change in the method of calculation of pensionable salary. It will be 60 months again average against the 12 months which was before 2014. Members retired prior to this without exercising options are not allowed to submit the joint option now. They said that whoever retired before 1st September 2000 shall not be eligible to and who had not opted for joint option shall not be eligible now. Only the members who have exercised option prior to 1st September 2014 are allowed to exercise option, and that too within 4 months, latest by 3rd March 2023, which is coming ahead. So these were the decisions which were favoring the employee provident fund organization. What are the decisions which favor the employee or the ex-employee? It came back to the original decision that existing members as on 1/4/2014, 4 month time was given from 4th November, that is just November, December, January, February and March. 4 months has been allowed from till 3rd March by Supreme Court under Article 142 of Constitution of India to submit the joint option to opt for contribution on actual salary and pension rather than the ceiling limit. Then this joint declaration to be submitted by the employee and the employer in line with unamended para 11.3 and 11.4 EPS 95 scheme, the original scheme, with an undertaking to remit arrears with applicable interest. That whatever arrears shall be given, the employee shall remit all the arrears as applicable to the EPFO, and recovery of the additional contribution, that is 1.16 of salary, is ultra virus and it cannot be recovered from the members. So this was set aside. However, the decision is still going on it, and it has been suspended for the next 6 months. Then EPFO or Government of India has to make necessary arrangements so that this additional contribution can be generated from some other legitimate source within the scope of the act, which could be including enhanced rate of contribution from the employers. These are certain ideas which are coming up. But yes, the employees have got a option that if they want pension to increase from the ceiling limit to the actual salary, they have that option. So now what is the decision for retired employees or for serving employees? What decision they have to take, whether to go from increased pension contribution of 8.33% of actual salary, or and reduce the PF contribution, because the employer contribution will remain 12% only. The right now what was happening was 8.33% of 15,000, that is 1250 additional amount, more than 1250 was going to the provident fund corpus by the employer. But now if they opt for this option, joint option, that 8.33% of their actual salary will be given to the pension corpus, then the provident fund corpus will reduce. So they have to decide this, whether to continue with the existing pension contribution up to maximum 15,000, that is around 1250 contribution, and rest contribution to PF, or reduce the PF amount and increase the pension amount. So that balance the employee or the retired employees have to take whether the pension, more pension, more provident fund, less pension, or less provident fund, more pension. This is the decision which they have to take as an employee. And for the retired employees, if they go for higher pension and lesser provident fund, then this provident fund corpus has already been taken by them. If they haven't been taken, how will they remit the money so that this pension amount increases? So there are various issues and concerns which are yet to be answered in the judgment. What about the arrear amount? How much the employee will get as an arrear versus pension amount? Say for example, I have to give 30 lakhs to my pension account to get a pension amount of say 1 lakh rupees per month. So is it a balanced decision? I have to, employees are thinking of, because they don't know how much money they have to give. So arrear shall be payable from which date? From 95 to 2014, or the salary date, whatever is available to the database of the employer. Then how is it impacting the wage revisions, the pay revisions which has happened, or the restoration of the wages which has happened in between the life history of the service of the employee? What about the rate of interest? The rate of interest of pension corpus, the rate of interest of PF corpus, both. What will happen of that? Then whether spouse of the deceased employee can submit option or joint declaration or not? Can there be set off or due arrears against due pension? Say for example, I as a retired employee have to submit say 30 lakh rupees to get the enhanced pension amount per month. So what can this be set off by because I have already taken out my pension, provident fund money, I don't have anything in my provident fund. So can it be set off against the arrear of which I am going to get on the increased pension? How the arrear shall be payable by the employees who have already withdrawn the PF from the PF trust and are not drawing pension against EPS 95. So what about them? Can employees joined after 1st September 2014 also exercise this option of becoming a member of the EPS scheme after the Supreme Court judgment? So there are a lot of issues and concerns which are yet to be solved. Still, I tried to summarize the EPS in this video. So thank you so much for being connected to my channel and my video. Please continue learning. If you have any doubts, queries, please write in the comment box. Thank you so much. Take care. Stay blessed.